Labor laws. Frequently asked questions on labor laws. Q. 1. Discuss the nature and scope of Workmen's Compensation Act. Whether this act is applicable to workers of public sector also. Ans. Scope of the act. The Indian Workmen's Compensation Act, 1923, provides for compensation to a workman who becomes incapacitated due to any accidental injury in the course of employment. The Act owes its salient features to the common law relating to grant of compensation to the workman in England. In the interpretation of the Act, the Indian courts have been guided by the English decisions. The Act extends to the whole of India except the state of Jammu and Kashmir. It applies to all factories employing 10 or more persons and using power and to those factories which do not use power but employ 50 or more workers. The Act also applies to shipmasters and seamen of power-driven ships or non-power-driven ships of 500 or more tons. In general, it applies to all organized industries and hazardous occupations. Besides, the state government may extend the application of the Act to other occupations, which in its opinion are hazardous. The statement of objects and reasons appended to the Act says that, the growing complexity of industry in this country with the increasing use of machinery and consequent danger to the workman, along with the comparative poverty of workmen themselves, renders it advisable that they should be protected from hardships arising out from accidents. This Act initially applied only to workers employed otherwise than in clerical capacity and receiving monthly wages not exceeding 300 rupees in factories, mines and ports. To those engaged on the railways, tramways on loading, unloading ships at dock, etc., where mechanical power was used in a building trade, construction of bridges, telegraph and telephone lines and posts and overhead electric cables, in connection with sewers and in the brigade services. The Act also applied to specified occupational diseases and the Government of India was empowered to extend the list of such diseases as well as to hazardous occupations. Presently this Act applies to all workers other than those whose employment is casual nature. Applicability of Act to workers of public sector Section 2, N, of the Act reads as under. Workman means any person, other than a person whose employment is of a casual nature and who is employed otherwise than for the purposes of the employer's trade or business, who is I. A railway servant is defined in Clause 34 of Section 2 of the Railways Act, 1989, 24 of 1989, not permanently employed in any administrative district or subdivisional office of a railway and not employed in any such capacity as is specified in Schedule 2, or IA, a master, seaman or other member of the crew of a ship. B. A captain or other member of the crew of an aircraft. C. A person recruited for work abroad by a company, and who is employed outside India in any such capacity as is specified in Schedule 2 and the ship, aircraft or motor vehicle, or company, as the case may be, is registered in India, or E. Employed in any such capacity as is specified in Schedule 2. whether the contract of employment was made before or after the passing of this Act, and whether such contract is expressed or implied, oral or in writing, but does not include any person working in the capacity of a member of the armed forces of the Union, and any reference to a workman who has been injured shall, where the workman is dead, include a reference to his dependents or any of them. This section makes it clear that for being termed as a workman, a person has to be working in a contract employment as has been observed in any capacity. In Sunil Industries, M.S. versus Ramchandra Pradhan, Air 2001 South Carolina 220, it was observed that it is true that the Workmen's Compensation Act, 1923 has been amended on a number of occasions. However, in spite of numerous amendments, the legislature has purposely omitted to specifically provide that only a workman who is employed in a factory, as defined in the Factories Act, could make a claim. All that has been done is that in Schedule 2 of the Workmen's Compensation Act it is inter alia clarified that persons employed, otherwise than in a clerical capacity, in any premises wherein a manufacturing process is defined in Clause K of Section 2 of the Factories Act, 1948, is carried out are workmen. Significantly, the definition of the term factory, as appearing in Clause M of Section 2 of the Factories Act, 1948 has not been incorporated in the Workmen's Compensation Act. Thus, it is clear that for the Workmen's Compensation Act to apply, it is not necessary that the workman should be working in a factory as defined in the Factories Act, 1948. It has not been denied that the workshop of the appellant would fall under Clause K of Section 2 of the Factories Act. So whoever is workman within the meaning of Section 2(n) of Act will be entitled to protection of Workmen's Compensation Act irrespective of the fact that he is employed in private or public sector. Q. 2. Define and explain following. A. Dependent. B. Employer. C. Managing agent. D. Partial disablement. A. Total disablement. F. Wages. Uns. A. Dependent. Section 2(1) D of the Act defines dependent. Under this subsection, relations of a workman are divided into 3 classes. However, there is no preferential right amongst dependents to maintain claim application. The dependents are not classified in different categories in the sense that those specified in Category I will exclude others. Dependents belonging to any category may claim simultaneously. I. The first category includes a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, and a widowed mother. They are deemed in law as dependents of a workman whether they are in fact dependent on the earnings of the workman or not. In the second category of dependents are included a son and a daughter. They have to fulfill the following conditions, namely: A. They must be wholly dependent on the earnings of the workman at the time of his death. B. They must be infirm, and C. They must have attained the age of 15 years. The following are included in the third category of dependents provided they are wholly or in part dependent on the earnings of the workman at the time of his death. A. A widower. B. A parent other than a widowed mother. C. A minor illegitimate son. E. An unmarried illegitimate daughter. E. A daughter whether legitimate or illegitimate or adopted if married and minor, or if widowed and a minor. D. A minor brother or an unmarried sister or a widowed sister if a minor. A. A widowed daughter-in-law. F. A minor child of a predeceased son. G. A minor child of a predeceased daughter where no parent of the child is alive, or H. A parental grandparent if no parent of workman is alive. Explanation. For the purposes of subclause E and item F and G of subclause E, references to a son, daughter of child includes an adopted son, daughter or child respectively. In B. M. Hobibullah's case Air 1977 Mad. 390, it was observed dependency is a question of fact. Therefore, where a person claims compensation as a dependent of the deceased workman, he must establish that he is a dependent within the meaning of Section 2(1)(d) of the Act. In all those cases the question of payment of compensation is conditioned by such claimant being wholly or in part dependent upon the earnings of the workman. It is not necessary for the dependents to obtain written letters of administration or a succession certificate. Dependent does not include all the heirs of a workman but only those who, to some extent, depend upon him. Kinship coupled with dependency is made the sole criterion for a person to fall within the ambit of the definition of dependent. B. Employer. In view of Section 2(1)(a), employer includes the following. 1. Any body of persons whether incorporated or not. 2. Any managing agent of an employer. 3. Legal representative of a deceased employer, and 4. When the services of a workman are temporarily lent on hire to another person by the person with whom the workman has entered into a contract of service or apprenticeship means such other person while the workman is working for him. Till 1948, the liability to pay compensation under the Act was only that of the person with whom the workman has entered into a contract of service or apprenticeship. But later on the Act was amended so as to cover cases under Section 12 of the Act, which makes the borrowing employer also liable. If a person is employed for the purposes of any game or recreation and engaged or paid through a club, the manager or the members of the managing committee of the club will, for the purpose of the Act, be deemed to be the employer. C. Managing agent. Managing agent means any person appointed or acting as the representative of another person for the purpose of carrying on such other person's trade or business, but does not include an individual manager subordinate to an employer. Section 2(1)(f). In Bajanath Singh vs. OT Railway, Air 1960 Vol. 362, dependents of a workman, who died from an accident resulting from collision of a light engine with a trolley which he was plying, made General Manager OT Railway a party to their claim. The Allahabad High Court held that the manager of a railway is according to the definition of railway administration in Section 3(6) of the Railways Act, equated to the government. He, therefore, satisfied the definition of managing agent in the Workmen's Compensation Act, because he can be said to be running the department which he is directly concerned with. D. Partial disablement. Section 2(1)(g) defines partial disablement. Such disablement is of two kinds. I. Temporary partial disablement. J. Permanent partial disablement. The test of such disablement is the reduction in the earning capacity of the workman. If the earning capacity of a workman is reduced in relation to the employment he had been at the time of the accident resulting in such disablement, it is temporary partial disablement. If the injury caused by an accident results in the reduction of the earning capacity in respect of employment which the workman was capable of as specified in Part 2 of Schedule 1 shall be deemed to result in permanent partial disablement. Compensation under the Act is payable only if the injury caused by accident results in workman's disablement exceeding 3 days. To determine whether the injury is permanent or temporary, the courts have to see whether the injury has incapacitated the workman from every employment which he was capable of undertaking at the time of accident or merely from the particular employment in which he was at the time of the accident resulting in disablement. In the former case the disablement is partial but permanent, in the latter case it is temporary. In Calcutta Licensed Measures Bengal Chamber of Commerce vs. M.D. Hussain, Air 1969 Cull. 378 it was observed, loss of earning capacity or the extent of it is question of fact. It has to be determined by taking into account the diminution or destruction of physical capacity as disclosed by the medical evidence, and then it is to be seen to what extent such diminution or destruction would reasonably be taken to have disabled the affected workman from performing the duties which a workman of his class ordinarily performs. The following propositions are helpful in deciding the nature of disablement. I. Earning is not the same as earning capacity. There is difference between earning of a person and his capacity to earn. Rise in earning may be because of various factors and rise in wages is not decisive of any loss of earning capacity. Loss of physical capacity is not coextensive with loss of earning capacity. To what extent there is loss of earning capacity for every employment which the workman was capable of undertaking at the time or the employment in which he was engaged at the time of the accident as the case falls for consideration. A. Total disablement. According to Section 2(1) of Workmen's Compensation Act, 1923, total disablement means such disablement whether of a temporary or permanent nature as incapacitates a workman for all work which he was capable of performing at the time of accident resulting in such disablement, provided that permanent total disablement shall be deemed to result from every injury specified in Part 1 of Schedule 1 or from any combination of injuries specified in Part 2 thereof where the aggregate percentage of the loss of earning capacity is specified in said Part 2 against those injuries amounts to 100% or more. It was held in National Insurance Company Limited vs. Mohammed Salim Khan and another, 1992 LLJ 377 that if the workman is incapacitated to do all the work which he was capable of performing at the time of accident, it is a case of total disablement. It may be that in view of the injuries the workman is capable enough to render some other sort of work. But still, when there is incapacity to do the work which he was capable of performing by the date of the accident, it is a case of total disablement. The certificate of the doctor of physical impairment and loss of physical function is not material in deciding the question of total disablement. F. Wages. Wages includes any privilege or benefit which is capable of being estimated in money. Other than a traveling allowance or the value of any traveling concession or a contribution paid by the employer of a workman towards any pension or provident fund or a sum paid to a workman to cover any special expenses entailed on him by the nature of his employment. Section 2, 1, M. Bonus is wages. Dearness allowance and amenities of free water and accommodation come under the privileges and benefit is thus within the definition of wages. Overtime allowance is also wages. It has been held by the Mysore High Court in the case of Hindustan Aeronautics Limited vs. Bonjan, 1971-22, F.L. R. 808. That overtime allowance and outstation allowance are the privilege or benefit which the employee was entitled to get for working beyond specified hours and for his work at outstation. Maternity benefit payable to a woman delivering a child is also included in the term wages. In the case of Bharat Heavy Plate and Vessels Limited vs. Commissioner for Workmen's Compensation and Others, 1983, ILLJ 477, the term wages has been given a wider meaning. The court observed that the definition of wages includes overtime allowance drawn by the workman. The expression wages used in the Workmen's Compensation Act includes any privilege or benefit, which may be estimated in terms of money. It is to be noted here that following are not included in the term wages. I. Traveling allowance, or E. The value of traveling concession, or E. A contribution made towards any pension, or IV. A contribution made towards provident fund, or V. A sum paid to a workman to cover any special expenses entailed on him by the nature of his employment. Q. 3. What is employer's liability for compensation to workmen under Workmen's Compensation Act? Ans. Employer's liability for compensation. The liability of an employer to pay compensation is limited and is subject to the provisions of the Act. Under subsection 1 of Section 3, the liability of the employer to pay compensation is dependent upon the following four conditions. 1. Personal injury must have been caused to a workman. 2. Such injury must have been caused by an accident. 3. The accident must have arisen out of and in the course of employment, and 4. The injury must have resulted either in death of the workman or in his total or partial disablement for a period exceeding 3 days. The employer shall not be liable to pay compensation in the following cases. A. If the injury did not result in total or partial disablement of the workman for a period exceeding 3 days. B. In respect of any injury not resulting in death or permanent total disablement, the employer can plead I. That the workman was at the time of accident under the influence of drinks or drugs. E. That the workman willfully disobeyed an order expressly given or a rule expressly framed for the purpose of securing safety of workmen, and E. That the workman, having known that certain safety guards or safety devices are specifically provided for the purpose of securing the safety of workmen, willfully disregarded or removed the same. Employer's liability in case of occupational diseases according to Section 3(2) of Workmen's Compensation Act. If a workman employed in any employment specified in Part A of Schedule 3 contracts any disease specified therein as an occupational disease peculiar to that employment, or if a workman, whilst in the service of an employer in whose service he has been employed for a continuous period of not less than 6 months, which period shall not include a period of service under any other employer in the same kind of employment, in any employment specified in Part B of Schedule 3. Contracts any disease specified therein as an occupational disease peculiar to that employment. Or if a workman whilst in the service of one or more employers in any employment specified in Part C of Schedule 3 for such continuous period as the central government may specify in respect to each such employment, contracts any disease specified therein as an occupational disease peculiar to that employment, the contracting of the disease shall be deemed to be an injury by accident within the meaning of this section, and, unless the contrary is proved, the accident shall be deemed to have arisen out of, and in the course of, the employment, provided that if it proved a. That a workman whilst in the service of one or more employers in any employment specified in Part C of Schedule 3 has contracted a disease specified therein as an occupational disease peculiar to that employment during a continuous period which is less than the period specified under this subsection for that employment, and b. That the disease has arisen out of and in the course of the employment, the contracting of such disease shall be deemed to be an injury by accident within the meaning of this section. Provided further that if it is proved that a workman who having served under any employer in any employment specified in Part B of Schedule 3 or who having served under one or more employers in any employment specified in Part C of that schedule, for a continuous period specified under this subsection for that employment and he has after the cessation of such service contracted any disease specified in the said Part B or the said Part C, as the case may be, as an occupational disease peculiar to the employment and that such disease arose out of the employment, the contracting or the disease shall be deemed to be injury by accident within the meaning of this section. Contracting of any one the diseases specified in the Schedule 3 of the Act is deemed to be personal injury caused by accident out of and in the course of employment. These diseases are called occupational diseases. Schedule 3 is divided into Parts A, B and C to support any claim for compensation in case of occupational diseases. In Part A, no specified period of employment is necessary. In the case of Part B, The workman contracting the diseases must have been in the service of the employer for a continuous period of not less than 6 months. Regarding the disease in Part C, the workman must have been in continuous services of one or more employers for such period as the central government may specify. Arising out of and in the course of employment. The accident must arise out of and in the course of employment so as to attract the liability under Section 3 of the Act. These twin conditions must coexist before it can be said that the employer has incurred the liability. These two conditions will be involved if the following questions are answerable affirmatively. I. Whether at the moment of the accident the employer was obliged to present on that site by the express or implied term of contract of his service. E. Whether he was there in his capacity as an employee or merely as a member of the public. E. Whether he was at that time under the control or direction of the employer or was acting as a completely free man. IV. Whether his presence at the spot was incidental to his employment, and V. Whether there was a proximate connection between the employment and the accident. General Manager, BEST Undertaking Bombay vs. Mrs. Agnes, Air 1964 Supreme Court 193. In Sakina Bibi vs. Gujarat State Road Transport Corp. 1992 Lab. IC 365, it was observed that the accident must arise out of and in the course of an employment. Therefore, the personal injury by accident must arise both out of as well as in the course of a workman's employment. The expression "in the course of employment" means in the currency of the employment. The test is in the course of discharge of duties incidental to the contract of service. The employee must show that he was at the time of the accident engaged in employer's business or in furthering with business and was not doing something for his own benefit or accommodation. That he was doing something in discharge of his duty to his employer directly or indirectly imposed upon him by his contract of service. Section 3, 2a. In case of any employment mentioned in Part C of Schedule 3 where there are more than one employers. Subsection 2a of Section 3 authorizes the Commissioner to fix up the extent of responsibility of different employers in respect of the amount of compensation payable to a workman. Section 3.3. The central government or the state government after giving, by notification in the Official Gazette, not less than 3 months' notice of its intention so to do, may by a like notification add any description of employment to the employments specified in Schedule 3 and shall specify in the case of employments so added the diseases which shall be deemed for the purposes of this section to be occupational disease peculiar to those employments respectively and thereupon provisions of subsection 2 shall apply in the case of a notification by the central government within the territories to which this Act extends or in case of a notification by the state government within the state as if such diseases had been declared by this Act to be occupational disease peculiar to those employments. Section 3.4. The employer is liable to pay compensation only if the disease can be directly attributed to a specific injury by accident arising out of and in the course of his employment. Exceptions to this rule are the cases covered by subsections 2, 2a, and 3 of Section 3. Q. 4. What shall be the amount of compensation to a workman? Uns. Section 4 of the Act deals with the amount of compensation that a workman would be entitled to get under the Act. The amount of compensation depends upon the gravity of the injury and the nature of disablement. For the purpose of determination of compensation, the injuries have been divided into 4 categories, namely I. Death, E. Permanent total disablement, E. Permanent partial disablement, and IV. Temporary disablement, whether total or partial. I. Death compensation. If the injury from the accident results in the death of the workman, the compensation is payable by the employer to the dependents of the workman. In such cases, the amount of compensation is determined by making a reference to Schedule 4. In that schedule, 20 different levels of monthly wages are given in the first column, and the amount of compensation payable in respect of that wage level is given in the second column. The maximum amount payable to the dependent of a worker in case of death is 30,000 rupees, after the 1976 amendment. By the 1984 amendment, the rates of compensation in the event of death is further raised from a minimum of 7,200 rupees to 20,000, and a maximum of 90,000 rupees, from the present 30,000 rupees. The amount is payable in lump sum in such cases. E. Permanent total disablement compensation. In case of injuries not resulting in death, the amount of compensation depends upon the nature of the disablement. When there is 100% loss in the earning capacity of the injured workman, it is a case of permanent total disablement. Schedule 1, Part 1 of the Act enumerates 6 injuries with 100% loss of earning capacity. Apart from this, if the aggregate of the loss of earning capacity due to 2 or more injuries specified in Part 2 of Schedule 1 comes to 100% or more, then also it becomes a case of permanent total disablement. In such cases, the amount of compensation payable will be proportionate to the loss of earning capacity of the workman concerned based on the wages group he falls. Schedule 4 of the Act. E. Permanent partial disablement compensation. When the loss of earning capacity is below 100%, it partakes the nature of permanent partial disablement. Part 2 of Schedule 1 of the Act enumerates certain injuries as cases of permanent partial disablement, showing in their corresponding column of the percentage of loss of earning capacity. If the injury in question is one listed as Part 2 of Schedule 1, the loss of earning capacity can be easily seen from the corresponding column. In such cases, depending upon the wage structure of the concerned employee, he is entitled to compensation proportionate to the loss of earning capacity payable in the case of permanent total disablement. Compensation as stated in Schedule 4 of the Act. Compensation on unscheduled injuries, under Section 4, 1, c. 2. If the injury is not specified in Schedule 1, the amount of compensation shall be such percentage of the compensation payable in the case of permanent total disablement as is proportionate to the loss of earning capacity permanently caused by the injury. The loss of earning capacity is a question of fact. In Calcutta Licensed Measures vs. Mohammad Hussain, Air 1969 Cal. 378, the court laid down the following propositions. I. Earning is not the same as earning capacity. E. The rise in earning may be because of various factors, and rise in wages is not decisive of no loss of earning capacity. E. Loss of physical capacity is not coextensive with loss of earning capacity. IV. Loss of physical capacity or physical incapacity may be relevant not as to which extent there is loss of earning capacity. For every employment which the workman was capable of undertaking at that time, or the employment in which he was engaged at the time of the accident as the case falls for consideration. IV. Compensation in case of temporary disablement. For temporary disablement, whether total or partial, compensation is payable in the form of recurring half-monthly payments. The first such payment becomes due on the 16th day after the expiry of the waiting period of 3 days where such disablement lasts for a period of less than 28 days. Thereafter payments are made in half-monthly installments during the period the disablement lasts, or during a period of 5 years, whichever is shorter. The payment of half-monthly payment payable to a workman is shown in column 4 of the Schedule 4, that varies according to the particular wage group to which the workman concerned belongs. If the workman has received any amount by way of compensation except allowance towards medical treatment during the period of disablement prior to receipt of the first half-monthly payment, such amount shall be deducted from half-monthly payment. Subsection 1 of Section 4A provides that the compensation shall be paid as soon as it becomes due. Subsection 2 provides that if there is a dispute regarding amount of compensation claimed by a workman, where the employer accepts his liability but not to the extent claimed, the employer shall either provisionally pay the amount accepted by him to the workman or deposit it with the commissioner. Any provisional payment or deposit so made by the employer shall not prejudicially affect any claim by the workman of any further amount under the Act. The workman may accept the amount as payable by the employer provisionally and make further claim for any additional amount. The employer is bound to make provisional payment of any amount based on the extent of liability he accepts within 1 month from the date it fell due, whether in case of death or permanent or temporary disablement of any kind. Subsections 3 and 3A, which have been substituted by Amendment Act 30 of 1995, provide as follows. Where any employer is in default in paying the compensation due under this Act within 1 month from the date it fell due, the Commissioner shall a. Direct that the employer shall, in addition to the amount of the arrears, pay simple interest thereon at the rate of 12% per annum or at such higher rate not exceeding the maximum of the lending rates of any scheduled bank as may be specified by the central government, by notification in the Official Gazette, on the amount due, and b. If, in his opinion, there is no justification for the delay, direct that the employer shall, in addition to the amount of the arrears, and interest thereon, pay a further sum not exceeding 50% of such amount by way of penalty, provided that an order for the payment of penalty shall not be passed under Clause B, without giving a reasonable opportunity to the employer to show cause why it should not be passed. Q. 5. What is the law relating to calculation of wages and commutation of half-monthly payment under Workmen's Compensation Act? What is power of Commissioner to review in this regard? Ans. Calculation of wages. Section 5 of the Act provides that in this Act and for the purposes thereof, the expression, monthly wages, means the amount of wages deemed to be payable for a month's service, whether the wages are payable by the month or by whatever other period or at piece rate, and calculated as follows, namely, a. Where the length of service of the affected workman, preceding to the injury, is of at least 12 months. The monthly wages of the person will be 1/12 of the sum of the salary drawn during preceding 12 months. B. The second category of cases are those in which the period of employment of the affected person preceding to injury was of less than 1 month. In such cases the computation of monthly wages is done on a different basis. The wages earned by any other person engaged in the similar employment, similar to that of affected person, is taken to be a standard, and the same will be monthly wages of injured person. C. In other cases, including cases in which it is not possible for want of necessary information to calculate the monthly wages under clause B, the monthly wages shall be 30 times the total wages earned in respect of the last continuous period of service immediately preceding the accident from the employer who is liable to pay compensation divided by the number of days comprising such period. A period of service shall, for the purposes of this section, be deemed to be continuous which has not been interrupted by a period of absence from work exceeding 14 days. Computation of half-monthly payment. Any right to receive half-monthly payments may, by agreement between the parties, or, if the parties cannot agree and the payments have been continued for not less than 6 months, on the application of either party to the Commissioner, be redeemed by the payment of a lump sum of such amount as may be agreed to by the parties or determined by the Commissioner, as the case may be. Section 7. The Commissioner shall form an estimate of the probable duration of the disablement and shall award a sum equivalent to the total of the half-monthly payments which would be payable for the period during which he estimates that the disablement will continue, less 1/2% of that total for each month comprised in that period. Power of review. Any half-monthly payments payable under this Act, either under an agreement between the parties or under the order of a Commissioner, may be reviewed by the Commissioner on the application either of the employer or of the workman, accompanied by the certificate of qualified medical practitioner that there has been no change in pay condition of the workman or subject to rules made under this Act on application made without such certificate. Section 6. Any half-monthly payments may, on review as above, subject to the provisions of this Act, be continued, increased, decreased or ended if the accident is found to have resulted in permanent disablement, be converted to the lump sum to which the workman is entitled less any amount which he has already received by way of half-monthly payments. Section 6 of the Act makes an express provision for altering the amount once fixed as compensation on the ground of a subsequent change in the circumstances. But under the terms of the section it is limited to half-monthly payments which are prescribed by the Act for only temporary disablement, total or partial. If on examining an application for review by an employer in which the reduction or discontinuance of half-monthly payment is sought, and if it appears to the Commissioner that there is reasonable ground for believing that the employer has a right to such reduction or discontinuance, he may, at any time, issue an order withholding the half-monthly payments in whole or in part pending his decision on the application. Besides Section 6, there is no provision in the Act which empowers the parties to seek a reopening of the question of compensation, whether fixed by agreement or determined by award. Q. 6. What are the remedies open to a workman for injury to him from accident arising out of and in the course of his employment? Are the remedies mutually exclusive? When is right to compensation extinguished or suspended? Ans. The following remedies are available to a workman in respect of an injury by accident arising out of and in the course of his employment, namely: 1. A suit for damages in the civil court. 2. A suit in a civil court for compensation under Section 3 of the Workmen's Compensation Act. 3. Agreement with the employer providing for compensation under Section 28 of the Workmen's Compensation Act. 4. Claim under Section 10 of the Workmen's Compensation Act before the Commission appointed under the Act. Under subsection 5 of Section 3, no claim for compensation shall be maintainable by a workman in respect of any injury if he has already instituted a civil proceeding for damages in respect of pay. Same injury against the employer or any other person. So also no suit for damages shall be instituted by a workman in any court of law in respect of any injury in the following two circumstances. 1. If such workman has made a claim for compensation in respect of such injury before a commissioner, or 2. If the amount of compensation in respect of the injury has been settled by an agreement between the workman and the employer in accordance with the provision of the Act. In case of an injury caused by an accident, a workman has the following alternative remedies. I. He can claim compensation under this Act, or E. He can claim damages in torts, or E. He can claim under the Employers' Liability Act. Section 3, 5, imposes a bar on the recovery by the workman of compensation twice for the same injury. Suspension of right to get compensation. According to Section 11(2) of the Act, if a workman, on being required to do so by the employer under subsection 1, or by the Commissioner at any time, refuses to submit himself for examination by a qualified medical practitioner or in any way obstructs the same, his right to compensation shall be suspended during the continuance of such refusal or obstruction unless, in the case of refusal, he was prevented by any sufficient cause from so submitting himself. And again Section 11(3) says that if a workman, before the expiry of the period within which he is liable under subsection 1, to be required to submit himself for medical examination, voluntarily leaves without having been so examined, his right to compensation shall be suspended until he returns and offers himself for such examination. Notice of the accident an essential condition precedent. According to Section 10, no claim for compensation shall be entertained by a commissioner unless notice of the accident has been given in the manner hereinafter provided as soon as practicable after the happening thereof, unless the claim is preferred before him within 2 years of the occurrence of the accident, or, in case of death, within 2 years from the date of death. Q. 7. What is the law relating to notice of a claim under Workmen's Compensation Act? Ans. Notice in claims of the accident. Section 10. A workman who is injured by an accident must give a notice of it in writing. This has to be done as soon as practicable after the occurrence of the accident. No hard and fast rule can be laid down in regard to what is meant by as soon as practicable. It depends upon the individual circumstances. The notice must contain I. The name and address of the workman injured. E. The date of the accident. E. The cause of the injury. The notice has to be served upon the employer or on any one of the several employers or upon any person who is responsible to the employer for the management of the branch of trade or business where the injured workman was employed. It may be delivered to the person concerned by hand or sent by registered post. Any claim for compensation must be made within 2 years of the occurrence of the accident or in case of death, within 2 years from the date of death. Where the accident results in any physical or bodily injury, the date of the accident can be easily ascertained. In case of occupational disease specified in Schedule 3, it would not be possible to know exactly the date on which the disease was contracted. It has, therefore, been provided that in the case of an occupational disease, the first day of the period during which the workman was continuously absent from work in consequence of the contracting of such a disease, should be considered as the date of the accident. In case of partial disablement due to the contracting of any occupational disease which does not compel such workman to absent from duty, the period of 2 years for the purpose of making any claim for compensation shall be counted from the day the workman gives notice of the disablement to his employer. Where a person who has been in employment for a continuous period specified under Section 3(2), in respect of that employment, ceases to be so employed and develops symptoms of an occupational disease peculiar to that employment, within 2 years of the cessation of employment, the accident shall be deemed to have occurred on the day on which the symptoms were first detected. The object of giving such a notice is to enable the employer to check the fact of the accident having occurred to the workman in the course of this employment and also to enable the employer to take such steps as he may think fit to mitigate the consequence in the accident. No claim for compensation shall be turned down want to defect or irregularity in the notice in the following cases. A. Where the claim for compensation is made in respect of the death of the workman resulting from an accident which occurred on the employer's premises or at any place under the employer's control. at the time of the accident and the workman died on such premises or at place or premises belonging to employer or died without having left the vicinity of the premises or place where the accident occurred. B. Where the employer or any one of the several employers or any person responsible to the employer for the management of any branch of the trade or business in which the injured workman was employed had knowledge of the accident from any other source at or about the time it occurred. The Commissioner for Workmen's Compensation is empowered to condone any failure to give notice or prefer the claim if he is satisfied that the failure had been for sufficient cause. Q. 8. Write short note on A. Statement of fatal accident. B. Employer's liability to report fatal accidents. C. Compensation returns. D. Contracting out. Ans. A. Statement of fatal accident. Section 10A of Workmen's Compensation Act provides 1. Where a commissioner receives information from any sources that a workman has died as a result of an accident arising out of and in the course of his employment, he may send by registered post a notice to the workman's employer requiring him to submit, within 30 days of the service of the notice, a statement, in the prescribed form, giving the circumstances attending the death of the workman, and indicating whether, in the opinion of the employer, he is or is not liable to deposit compensation on account of the death. 2. If the employer is of opinion that he is liable to deposit compensation, he shall make the deposit within 30 days of the service of the notice. 3. If the employer is of opinion that he is not liable to deposit compensation, he shall in his statement indicate the grounds on which he disclaims liability. 4. Where the employer has so disclaimed liability, the Commissioner, after such inquiry as he may think fit, may inform any of the dependents of the deceased workman that it is open to the dependents to prefer a claim for compensation, and may give them such other further information as he may think fit. B. Employer's liability to report fatal accidents. Section 10B, where under the provision of any other law in force, the employer or someone on his behalf is required to give notice of any accident occurring on his premises which results in death or serious bodily injury. The person so required to give notice shall within 7 days of such occurrence send a report to the Commissioner giving the circumstances attending death or serious bodily injury. Where the state government has so prescribed, the person required to give notice may, instead of sending such report to the Commissioner, send it to the authority to whom he is required to give the notice. For the purpose of this section, serious bodily injury means an injury which involves or in all probability will involve I. The permanent loss of the use of, or permanent injury to any limb, or e. The permanent loss of or injury to the sight or hearing, or e. The fracture of any limb, and iv. Any injury which compels the injured person to be absent from his work for a period exceeding 20 days. This notice has to be given in a form prescribed by the government stating therein 1. The time of accident. 2. Place where accident occurred. 3. Manner in which the deceased was employer, and 4. Cause of the accident. In addition to this, the following particulars of the workman should also be supplied. 1. Name. 2. Sex. 3. Age. 4. Nature of employment. And 5. Postal address. The provisions of Section 10B of the Workmen's Compensation Act do not apply to factories to which the Employees State Insurance Act, 1948 applies. C. Compensation return. Section 16 of the Act provides that the state government may, by notification in the Official Gazette, direct that every person employing workmen, or that any specified class of such persons shall send at such time and in such form and to such authority, as may be specified by state government by notification, a correct return specifying the number of injuries in respect of which compensation has been paid by the employer during the previous year and the amount of such compensation, together with such other particulars as to the compensation as the state government may direct. Whoever fails to make a return, as required above, shall be punishable with fine, which may extend to 500 rupees. Section 18A, 1. D. Contracting out. Section 17 of the Act provides that any contract or agreement, whether made before or after the commencement of this Act, whereby a workman relinquishes any right of compensation from the employer for personal inquiry arising out of or in the course of the employment, shall be null and void in so far as it purports to remove or reduce the liability of any person to pay compensation under this Act. Q. 9. What is the provision under Workmen's Compensation Act regarding medical examination? What is consequence for refusing to be attended by qualified medical practitioner by injured? Uns. Section 11 of the Workmen's Compensation Act provides in this regard. A workman who is injured and has given notice of an accident to the employer shall submit himself for medical examination if offered by the employer. Any such offer made by the employer must be free of charge and made within 3 days from the time at which service of the notice has been effected. So also any workman who receives half-monthly payment shall submit himself for medical examination if and when required by the employer. Any workman shall be required to submit himself for examination by a medical practitioner only in accordance with the rules made under this Act and at such intervals as prescribed by these rules. If a workman refuses to submit himself for examination by a qualified medical practitioner as required either by the employer or the commissioner, his right to compensation shall be suspended for the period of refusal or obstruction. In these cases he will be entitled to full compensation only if he can show that he was for some sufficient cause prevented from submitting himself. If any such refusal or obstruction by the workman leads to the aggravation of injury, he shall be entitled to compensation for only such disablement which would have resulted if the injury would have been properly treated. Difficulty arises where the medical treatment results in deterioration of the injury. If the intervening act is the direct or foreseeable consequence of the defendant's act, then the doctrine novus actus interveniens does not apply. Nor does it apply where the intervening actor is not fully responsible or if his act is intentionally procured by the plaintiff. Where the workman whose right to compensation has been suspended under subsections 2 and 3 of Section 11, dies without having submitted himself for medical examination as required. The Commissioner may, if he thinks fit, direct the payment of compensation to the dependents of the deceased workman. But no compensation in such cases shall be payable in respect of the period of suspension, and if the period of suspension commences before the expiry of the waiting period referred to in Clause D of subsection 1 of Section 4. The waiting period shall be increased by the period during which the suspension continues. The aggravation of any injury shall not be taken into consideration in the assessment of compensation in the following cases under Section 11(6). I. Where an injured workman has refused to be attended by a qualified medical practitioner whose services have been offered to him by the employer free of charge, or e. Where the injured workman has deliberately disregarded the instructions given by a qualified medical practitioner. Provided it is proved that such refusal, disregard or failure was unreasonable in the circumstances of the case. The purpose of medical examination is to prevent a dishonest worker having an opportunity of concealing the nature of his injury from any impartial observer, and the certificate or evidence given by the employer's doctor cannot, however, be considered to be conclusive. In case the employer doubts the bona fide of the workman, he may get him examined by a competent medical practitioner free of cost, but he cannot demand of the worker a medical certificate. Q. 10. Discuss liability of principal and contractor in respect of compensation payable under Workmen's Compensation Act. Ans. Where the principal in the course of or for the purpose of his trade or business contracts with any contractor for the execution by or under the contract of the whole or any part of any work which is ordinarily part of the trade or business of the principal. The principal shall be liable to pay to any workman employed in the execution of the work any compensation which he would have been liable to pay if that workman had been immediately employed by him, and where compensation is claimed from the principal. This act shall apply as if reference to the principal were substituted for reference to the employer, except that the amount of compensation shall be calculated with reference to the wages of a workman under the employer by whom he is immediately employed. Where the principal is liable to pay compensation under this section, he shall be entitled to be indemnified by the contractor or any other person from whom the workman could have recovered compensation, and where a contractor who is himself a principal is liable to pay compensation or to indemnify a principal under this section, he shall be entitled to be indemnified by any person standing to him in the relation of a contractor from whom the workman could have recovered compensation, and all questions as to the right to and the amount of any such indemnity shall, in default of agreement, be settled by the Commissioner. This section shall not prevent a workman recovering compensation from the contractor instead of the principal. It will, however, not apply in case where the accident occurred elsewhere than on, in or about the premises on which the principal has undertaken or usually undertakes, as the case may be, to execute the work, or which are otherwise under his control or management. Section 12. In the case of Executive Engineer PWD vs. Sabia Nikkar and another, 1983, 2 LLJ 320. The question as to whether an award for compensation can be passed against the principal employer under the provisions of Section 12 was settled. In this case it was laid down that in the light of the provisions of Section 12 it was very much clear that the legislature has clearly and specifically provided that an award for compensation is to be passed directly against the principal employer, and at the same time the principal employer is given a right of indemnification as against the contractor. In such circumstances, the additional commissioner is entitled to pass an award granting compensation either in full or in part directly against the principal employer with the condition precedent that the principal employer will get indemnified by the contractor. Q. 11. What protection has been provided to workmen for compensation, in case of insolvency of employer? Ans. Section 14 of Workmen's Compensation Act provides 1. Where any employer has entered into a contract with any insurer in respect of any liability under this Act to any workman, then in the event of the employer becoming insolvent or making a composition or scheme of arrangement with his creditors, or, if the employer is company, in the event of the company having commenced to be wound up, the rights of the employer against the insured as respects that liability shall, notwithstanding anything in any law for the time being in force relating to insolvency or the winding up of companies, be transferred to invest in the workman. And upon any such transfer the insurers shall have the same rights and remedies and be subject to the same liabilities as if they were the employer, so, however, that the insurer shall not be under any greater liability to the workman than they would have been under to the employer. 2. If the liability of the insurers to the workman is less than the liability of the employer to the workman may prove for the balance in the insolvency proceedings of liquidation. 3. Where in any case such as is referred to in subsection 1, the contract of the employer with the insurers be void or voidable by reason of non-compliance on the part of the employer with any terms or conditions of the contract, other than a stipulation for the payment of premium. The provisions of that subsection's whole apply as if the contract were not void or voidable, and the insurers shall be entitled to prove in the insolvency proceedings or liquidation for the amount paid to the workman, provided that the provisions of this subsection shall not apply in any case in which the workman fails to give notice to the insurers of the happening of the accident and of any accident resulting in disablement as soon as practicable after he becomes aware of the institution of the insolvency or liquidation proceedings. 4. There shall be deemed to be included among the debts which under Section 49 of the Presidency Towns Insolvency Act, 1909, 33 of 1909, or under Section 61 of the Provincial Insolvency Act, 1920, 5 of 1920, or under Section 530 of the Companies Act, 1956, 1 of 1956, are in the distribution of the property of an insolvent or in the distribution of the assets of a company being wound up to be paid in priority to all other debts. The amount due in respect of any compensation the liability wherefore accrued before the date of the order of adjudication of the insolvent or the date of the commencement of the winding up, as the case may be, and those acts shall have effect accordingly. 5. Where the compensation is a half-monthly payment, the amount due in respect thereof shall, for the purposes of this section, be taken to be the amount of the lump sum for which the half-monthly payment could, if redeemable, be redeemed if applications were made for that purpose under Section 7. And a certificate of the Commissioner as to the amount of such sum shall be conclusive proof thereof. 6. The provisions of subsection 4 shall apply in the case of any amount for which an insurer is entitled to prove under subsection 3. But otherwise those provisions shall not apply where the insolvent or the company being wound up has entered into such a contract with insurers as is referred to in subsection 1. 7. This section shall not apply where a company is wound up voluntarily merely for the purpose of reconstruction or of amalgamation with another company. In R.B. Mundra and Company vs. M.S.T. Bhavari, Air 1970 Raj 111. It was observed the Commissioner for the Workmen's Compensation has no jurisdiction to award compensation to a workman against the insurance company unless the case falls within Section 14 of the Act. Because the term employer, as defined in the Act, does not cover the insurance company. Q. 12. What is the procedure of making reference to Commissioner? What particulars are to be given in an application to Commissioner for Workmen's Compensation? What are his powers in deciding such claims? Ans. Section 19 of Workmen's Compensation Act provides 1. If any question arises in any proceedings under this Act as to the liability of any person to pay compensation, including any question as to whether a person injured is or is not a workman, or as to the amount or duration of compensation, including any question as to the nature or extent of disablement, the question shall, in default of agreement, be settled by a Commissioner. 2. No civil court shall have jurisdiction to settle, decide or deal with any question which is by or under this Act required to be settled, decided or dealt with by a Commissioner, or to enforce any liability incurred under this Act. So any Commissioner of an area concerned shall have the power to decide and settle all questions as to the liability of any person to pay compensation. In default of an agreement between the parties to arrive at a conclusion in respect of any claim to compensation, the Commissioner has jurisdiction to decide inter alia. I. The question as to whether a person injured is a workman. E. The liability of any person to pay compensation. E. The amount and duration of compensation. IV. The nature or extent of disablement. In Pratap Narain Singh Dio vs. Srinivas Sabata, Air 1976 South Carolina 222, it was observed that in case of a personal injury caused to a workman by an accident which arises out of and in the course of employment, unless the right to compensation is taken away under subsection 5 of Section 3, the employer becomes liable to pay the compensation as soon as the aforesaid personal injury is caused to the workman. Section 19 only provides for settlement by the Commissioner of any question regarding liability of any person to pay compensation or the amount or duration of compensation. In default of any agreement if such question arises in any proceeding under the Act. The section does not have the effect of suspending the liability of an employer to pay compensation under Section 3 till after the settlement contemplated under Section 19. It is the duty of the employer to pay compensation under Section 4A(1) at the rate provided by Section 4 as soon as the personal injury is caused to the workman. Where the employer fails to do so and also makes no provisional payment under Section 4(2), but challenges the jurisdiction of the Commissioner, the employer is liable to pay interest and penalty. Section 19 refers to a liability arising by virtue of this Act. The liability adjudicate upon by Claims Tribunal under the Motor Vehicles Act is a liability founded in tort and thus falls outside the scope of this section. The Commissioner acting under the Workmen's Compensation Act is a tribunal and not a civil court. He constitutes an independent tribunal. His function is to judge and decide and not merely to inquire and advise, and in judging and deciding the matters before him, he has to proceed judiciously and not arbitrarily. Further, the civil court has no jurisdiction to enforce any liability incurred under the Workmen's Compensation Act. Thus the jurisdiction of the civil court is expressly barred by Section 19(2), in respect of any matter that falls within the jurisdiction of the Commissioner for Workmen's Compensation. Section 20. Appointment of Commissioner. For the purpose of deciding the question of the liability of any person to pay compensation under the Act, the state government has been authorized to appoint any person as the Commissioner for Workmen's Compensation. The state government in the official gazette must notify the appointment. The government must specify the area of jurisdiction of a commissioner by such notification. If more than one commissioner have been appointed for the same area, the state government may by general or special order regulate the distribution of business between them. The Commissioner may take the assistance or the services of any person who is an expert in the matter referred to him for decision. Any such person shall assist the Commissioner in holding the inquiry. Under Section 22 of the Act. 1. No application for the settlement of any matter by a commissioner, other than an application by a dependent or dependents for compensation, shall be made unless and until some question has arisen between the parties in connection therewith which they have been unable to settle by agreement. It simply means that if the parties are able to settle matter of compensation between them, the application may not be made because in that case the agreement made by them will govern their rights and liabilities. 2. An application for payment of compensation to Commissioner is to be made in prescribed form, and the same is to be accompanied by the prescribed fee if any. In addition to the other particulars, the application for compensation is to contain following facts also. A concise statement of circumstances in which the application is made and the relief or order which the applicant claims. B. In the case of a claim for compensation against an employer, the date of service of notice of the accident on the employer and if such notice has been served or has not been served in due time. The reason for such omission. C. The name and address of the parties, and D. Except in the case of an application by dependents for compensation, a concise statement of the matters on which agreement has and those on which agreement has not come to. 3. If the applicant is illiterate or for any other reason is unable to furnish the required information in writing, the application shall, if the applicant so desires, be prepared under the direction of the Commissioner. Power of Commissioner. Section 23 of the Workmen's Compensation Act lays down that the Commissioner shall have all the powers of the Civil Court under the Civil Procedure Code, for the purpose of taking evidence on oath, and of enforcing the attendance of witness and compelling the production of documents and material objects. And the Commissioner shall be deemed to be a civil court for all the purposes of Section 195 and of Chapter 30 of the Code of Criminal Procedure. The Commissioner has discretion to all costs incidental to any proceeding before him. A Commissioner may, if he thinks fit, submit any question of law for the decision of the High Court, and if he does so, shall decide the question in conformity with such decision. Q. 13. Discuss the historical background of Factories Act. Also discuss object and scope of Act. Ans. History. The factory legislation in India has a bearing with the factory legislation of England. In England and other Western countries, laissez-faire philosophy in the 19th century resulted in the emergence of new problems and new evils inside and outside the factories. New regulations became inevitable to improve the lot of the workers and to eradicate the miseries and other defects faced by the workers in the factories. In India, for the first time, public attention was drawn to the miserable conditions of factory workers in a report published in 1873. The first Factory Act was passed in 1881, by which children were allowed to work for 9 hours a day from the age of 8 onwards. The Factory Act of 1911 further improved the situation by securing 1 weekly holiday for all workers in factories and fixing a maximum 11 hours work a day for women with 1.5 hours rest. It also prohibited the work of women and children at night and raised the age of children permitted to work in mills from 8 to 9 years with maximum 7 hours work a day. The 1911 Factories Act was replaced by the 1934 Factories Act. The 1934 Factories Act of India provided for various matters. However, this act was also found to be quite inadequate. The provisions relating to safety, health and welfare of the workers provided in the 1934 Act were found to be quite inadequate and unsatisfactory, and further the ambit and scope of the Act did not extend to the large mass of workers employed in workplaces not covered by the Act. This demanded for a more comprehensive legislation like the existing Factories Act, 1948. Object of the Act. The 1948 Act was also designed to implement many provisions of the International Labour Organization Code of Industrial Hygiene. The object of the Act is to protect human beings from subjecting to unduly long hours of bodily strain or manual labor. It also provides that employee should work in healthy and sanitary conditions so far as the manufacturing processes will allow, and that precautions should be taken for their safety and for the prevention of accidents. The Act was intended to consolidate and amend the law regulating to labor in factories. Scope and features of the Act. The Act has cured many of the existing defects, done away with the distinction between seasonal and perennial factories, raised the minimum age of children from 12 to 13, and reduced their working hours from 5 to 4 hours. The Act provides certain minimum requirements regarding health, cleanliness, ventilation, temperature, dangerous dust and fumes, lighting and control of glare, and safety and general welfare of workers. The notable feature of the Act is following. 1. The definition of factory is made more comprehensive to include many establishments employing 10 or more workmen with the aid of power or 20 more workmen without the aid of power. 2. By the 1976 Factories Amendment Act, the definition of factory is further widened to include within its ambit the contract labor also for the purpose of computing the 10 or 20 limit of workers in order to determine the total strength of the workers for the purpose of the Act. 3. The distinction between seasonal and perennial factories had been done away with. 4. The minimum age of children for employment has been raised from 12 to 14 and their working hours reduced from 5 to 4-1/2. With powers of provincial government to prescribe even a higher minimum age for employment in hazardous undertakings. 5. Certain basic minimum facilities regarding health, safety and welfare of workers are duly dealt with under the Act. 6. Employment of children and women is prohibited between 7 p.m. and 6 a.m. in the factory. 7. The Act also lays down provisions for licensing and registration of a factory requiring prior scrutiny by factory inspectors of the plant and specifications. 8. Under the Factories Amendment Act, 1976, the Chief Inspector or the Director General of Factory Advice Service and Labor Institute of the Director General of Health Service, or any authorized person on their behalf can undertake safety and occupational health surveys for the safety and welfare of the factory workers. Q. 14. Define and explain following terms under Factories Act 1948. I. Adult. E. Adolescent. E. Child. IV. Competent person. V. Power. V. Prime mover. V. Transmission machinery. V. Machinery. X. Manufacturing process. X. Worker. She. Factory. Xi. Occupier. Uns. I. Adult. As defined in Section 2, a. Adult means a person who has completed 18 years of age. E. Adolescent. Adolescent means a person who has completed his 15th year of age but not completed his 18th year. Section 2, b. E. Child. Child means a person who has not completed his 15th years of age. Section 2, c. IV. Competent persons. In relation to any provision of this Act means a person or an institution recognized as such by the Chief Inspector for the purposes of carrying out tests, Examinations and inspections required to be done in a factory under the provisions of this Act having regard to I. The qualifications and experience of the person and facilities available at his disposal, or e. The qualification and experience of the persons employed in such institution and facilities available therein. With regard to the conduct of such tests, examinations and inspections, and more than one person or institution can be recognized as competent person in relation to a factory. V. Power. Power means electrical energy or any other form of energy which is mechanically transmitted or is not generated by human or animal agency. Section 2 grams. V. Prime mover. Prime mover means any engine, motor or other appliance, which generates or otherwise provides power. Section 2 H. V. Transmission machinery. Transmission machinery means any shaft, drum, pulley, system of pulleys, coupling, clutch, driving belt or other appliance or device by which the motion of a prime mover is transmitted to or received by any machinery or appliance. Section 2 I. V. Machinery. Machinery includes prime mover, transmission machinery and all other appliances whereby power is generated, transformed, transmitted or applied. X. Manufacturing process. Manufacturing process means any process for I. Making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing, or otherwise treating or adapting any article or substance with a view to use. Sale, transport, delivery or disposal, or e. pumping oil, water, sewage or any other substance, or e. generating, transforming power, or transmitting power, or IV. Composing types for printing, printing by letterpress, lithography, photogravure or other similar process or bookbinding, or V. Constructing, reconstructing, repairing, refitting, finishing or breaking up ship or vessels, or V. Preserving or storing any article in cold storage. In V.P. Gopala Rao vs. Public Prosecutor, Andhra Pradesh, Air 1970 SC 66, it was observed that manufacturing processes as defined in Section 2, K. I, were carried on in the premises. Under Section 2, K. I, manufacturing process means any process for making, altering, repairing, ornamenting, finishing, packing, oiling, washing, cleaning, breaking up, demolishing or otherwise treating or adapting any article or substance with a view to its use, sale, transport, delivery or disposal. The definition is widely worded. The moistening was an adaptation of the tobacco leaves. The stalks were stripped by breaking them up. The leaves were packed by bundling them up and putting them into gunny bags. The breaking up, the adaptation and the packing of the tobacco leaves were done with a view to their use and transport. All these processes are manufacturing processes within Section 2, K. I. In State of Kerala vs. V. M. Patel, 1961-1 Lab LJ 549, SC, the court held that the work of garbling pepper by winnowing, cleaning, washing and drying it on concrete floor, and a similar process of curing ginger dipped in lime and laid out to dry in a warehouse were manufacturing processes. In Call, Sardar C.S. Angre vs. the State, ILR 1965-15 Raj 117. AIR 1965 Raj 65. It was held that it is sufficient to say that the work of sorting and drying potatoes and packing and repacking them into bags was held not to be a manufacturing process as the work was done for the purpose of cold storage only and not for any of the purposes mentioned in Section 2, K. I. X. Worker. Worker means a person employed directly or by or through any agency, including a contractor, with or without the knowledge of the principal employer, whether for remuneration or not. In any manufacturing process, or in cleaning any part of the machinery or premises used for a manufacturing process, or in any other kind of work incidental to or connected with the manufacturing process or the subject of the manufacturing process. But work does not include any member of the armed forces of the Union. Section 2, 1. In State of Bombay vs. Ali Sahib Kashim Tamboli. Air 1955 Bom 209, it was observed that a person, in order to be a worker within the meaning of this section, need not necessarily. Therefore, a person working on any manufacturing process in a factory is a worker even though he does not receive wages. The expression "whether for wages or not," used in this subsection means whether the person receives wages as remuneration for his services, or such person is an apprentice learning work, or as an honorary worker. Whether a person is always a worker or not is a question of fact in each case. In Chintaman Rao vs. State of Madhya Pradesh, 1958 1340 Seychelles rupees. Air 1958 South Carolina 388, the court gave a restricted meaning to the words, directly or through an agency, in Section 2, 1, and held that a worker was a person employed by the management and that there must be a contract of service and a relationship of master and servant between them. On the facts of that case, the court held that certain septadars were independent contractors and that they and the coolies engaged by them for rolling bidis were not workers. In V.P. Gopala Rao vs. Public Prosecutor, Andhra Pradesh, Air 1970 SC 66, it was observed that a worker, within meaning of Section 2, 1, is a person employed by the management and there must be a contract of service and a relationship of master and servant between them. It is a question of fact in each case whether the relationship of master and servant exists between the management and the workman. The critical test of the relationship of master and servant is the master's right of superintendence and control of the method of doing the work. In the instant case, there was prima facie evidence showing that the relationship of master and servant existed between the workman and the management. In Lal Muhammad vs. Indian Railway Construction Company, Limited, Air 1999 South Carolina 355, it was observed that all the workers employed by the construction company would squarely attract the definition of the term "workman", as found in Section 2, L. of the Factories Act as they are working for remuneration in a manufacturing process carried out by the project. Thus all the requirements of the term "factory", as defined by Section 2 meters of the Factories Act, are satisfied on the facts of the present case. Factory. Factory means any premises including the precinct thereof. Whereon 10 or more workers are working, or were working on any day of the preceding 12 months. And in any part of which a manufacturing process is being carried on with the aid of power or is ordinarily so carried on, or whereon 20 or more workers are working, or were working on any of the preceding 12 months and in any part of which a manufacturing process is being carried on without the aid of power, or is ordinarily so carried on. Factory does not include a mine subject to the operation of the Mines Act, 1952 or a mobile unit belonging to the armed forces of the Union, a railway running shed or hotel, restaurant or eating place. Explanation For computing the number of workers for the purposes of this clause, all the workers in different groups and relays in a day shall be taken into account. Explanation 2. For the purpose of this clause, the mere fact that an electronic data processing unit or a computer unit is installed in any premises or part thereof shall not be construed to make it a factory if no manufacturing process is being carried on in such premises or part thereof. The phrase, premises including precincts, means both premises within premises without precincts. Where a premises is a building it would include precincts also, but where premises are lands, they would not have precincts. Thus both buildings and lands are covered by the above expression. It was held in State of Bombay vs. Ardeshir Homosji Bhivandiwala, 1956, ILLJ 26 that lands in which the process of manufacturing salt is carried on is a factory. In Grower and Weil, India, Limited, M.S. versus Collector of Central Excise, Baroda, Air 1995 South Carolina 543. It was observed that the words, any premises including the precincts thereof, under Section 2 meters of the Factories Act are wide enough to include all buildings with its surroundings which form part of one unit. If therefore in such an area 10 or more workers are working and in any part thereof manufacturing process are being carried on with the aid of power, it would be a factory within the meaning of Section 2 meters. Occupier. Occupier of a factory means the person who has ultimate control over the affairs of the factory, provided that in the case of a firm or other association of individuals, any one of the individual partners or members thereof shall be deemed to be the occupier. In the case of a company, any one of the directors shall be deemed to be the occupier. In the case of a factory owned or controlled by the central government, or any local authority, the person or persons appointed to manage the affairs of the factory by the central government, the state government or the local authority, as the case may be, shall be deemed to be the occupier. Provided further that in the case of a ship which is being repaired, or on which maintenance work is being carried out, in a dry dock which is available for hire, 1. The owner of the dock shall be deemed to be the occupier for the purposes of any matter provided by or under a. Section 6, Section 7, Section 7A, Section 7B, Section 11 or Section 12. B. Section 17 insofar as it relates to the providing and maintenance of sufficient and suitable lighting in or around the dock. C. Section 18, Section 19, Section 42, Section 46, Section 47 or Section 49, in relation to the workers employed on such repair or maintenance. 2. The owner of the ship or his agent or master or other officer in charge of the ship or any person who contracts with such owner, agent or master or other officer in charge to carry out the repair or maintenance work shall be deemed to be the occupier for the purposes of any matter provided for by or under Section 14. Section 15, Section 16, or Section 17, save as otherwise provided in this proviso, or Chapter 4, except Section 17, or Section 43, Section 44 or Section 45, Chapter 6, Chapter 7, Chapter 8 or Chapter 9 or Section 108, Section 109 or Section 110, in relation to a. The workers employed directly by him, or by or through any agency, and b. The machinery, plant or premises in use for the purpose of carrying out such repair or maintenance work by such owner, agent, master or other officer in charge or person. Section 2, N. In Donald Mackenzie v. Chief Inspector of Factories, Air 1962 South Carolina 1351, the expression "occupier", as defined in Section 2, N, of Factories Act is not to be equated with "owner". No doubt the ultimate control over a factory must necessarily be with an owner unless the owner has completely transferred that control to another person. Whether that was done in a particular case is a question of fact. Therefore, the manager of a factory who claims to be an occupier of the factory must lay before the chief inspector of the factories the necessary material for showing that the company had in some manner transferred the entire control over the factory to him. In the absence of such material, an application for renewal of license signed by the manager is not in proper form and cannot be acted upon. In Indian Oil Corporation Limited v. Chief Inspector of Factories, Air 1998 South Carolina 2456, it was observed that for the purpose of Section 2, N, what is to be seen is who has the "ultimate control" over the affairs of the factory. As the factories run by the Indian Oil Corporation are effectively and really owned and controlled by the central government, they fall within the purview of Clause E, and not Clause E, of the first proviso to Section 2, N. The persons appointed by the central government to manage the affairs of the factories should be deemed to be the occupiers of those factories for the purposes of Section 2, N, of the Factories Act. In Kanpur Suraksha Karamchari Union, RUGD, versus Union of India, Air 1988 South Carolina 1965, it was observed that under Clause E of Section 2, N, of the Act, in the case of a factory owned or controlled by the central government, the person or persons appointed to manage the affairs of the factory by the central government shall be deemed to be the "occupier". Q. 15. How inspectors are appointed and what are the powers given to them under the Act? Ans. The Act envisaged 6 types of inspectors, namely, inspectors, chief inspectors, additional inspectors, additional chief inspectors, joint chief and deputy chief inspectors. The state government may by notification in the official gazette appoint such persons as possessed of the prescribed qualifications to be inspectors and may assign to them such local limits as it may think fit. Chief inspectors who shall be similarly appointed shall, in addition to the powers of an inspector throughout the state, every district magistrate shall be an inspector for his district. The state government may also by notification as aforesaid appoint such public officer as it thinks fit to be additional inspectors for all or any of the purposes of the Act. Every chief inspector, additional chief inspector, joint chief inspector, deputy chief inspector, inspector and every other officer appointed under Section 8 shall be deemed to be public officer within the meaning of the term as used in the Indian Penal Code. Also no such officer shall continue to hold office after becoming directly or indirectly interested in a factory or in any process or business carried on therein or in any patent or machinery connected therewith. In any area where there are more inspectors than one, the state government may, by notification in the official gazette, declare the powers, which such inspectors shall respectively exercise in the inspector to whom the prescribed notices are to be sent. Power of inspectors. An inspector may exercise the following powers subject to any rules made in this behalf and within the local limits for which he is appointed. A. Enter with such assistance, being person in the service of the government, or any local or other public authority, or with an expert as he thinks fit any place which is used, or which he has reason to believe is used as a factory. B. Make examination of the premises, plant and machinery, article or substance, require the production of any prescribed register and any other document relating to the factory, and take on the spot or otherwise statement of any persons which he may consider necessary for carrying out the purposes of this Act, and c. Exercise such other powers as may be prescribed for carrying out the purposes of this Act, provided that no persons shall be compelled under this section to answer any question or give any evidence tending to incriminate himself. Section 9. Q. 16. What safeguards have been provided under Factories Act for protection of health of workers? Ans. Chapter 3 of Factories Act deals with safeguards provided for protection of health of factory workers. Section 11 lays down that every factory shall be kept clean and free from effluvia arising from any drain, privy or other nuisance. The following precautions shall be taken in particular. A. Accumulation of dirt and refuse shall be removed daily by sweeping or by any other effective method from the floors and benches of workrooms and from staircases and passages and disposed of in a suitable manner. B. The floor of every workroom shall be cleaned at least once in every week by washing, using disinfectant, where necessary or by some other effective method. C. Where a floor is liable to become wet in the course of any manufacturing process to such extent as incapable of being drained, effective means of drainage shall be provided and maintained. D. All inside walls and partitions, all ceilings or tops of rooms and all walls, sides and tops of passages and staircases shall I. Where they are painted otherwise than with washable water paint or varnished, be repainted or revarnished at least once in every period of 5 years. I. Where they are painted with washable water paint be repainted with at least one coat of such paint at least once in every period of 3 years and washed at least once in every period of 6 months. E. Where they are painted or varnished or where they have smooth impervious surfaces, be cleaned at least once in every period of 14 months by such method as may be prescribed. E. In any other case, be kept whitewashed or color washed, and the whitewashing or color washing shall be carried out at least once in every period of 14 months. D. All doors and window frames and other wooden or metallic framework in shutters shall be kept painted or varnished and the painting or varnishing shall be carried out at least once in every period of 5 years. A. The date on which the process required by clause D is carried out shall be entered in the prescribed register. Section 11(2) lays down, if in view of the nature of the operations carried on in a factory or class or description of factories or any part of factory or any class or description of factories, it is not possible for the occupier to comply with all or any of the provisions of subsection 1. The state government may by order exempt such factory or class or description of factories or part thereof from any of the provisions of that subsection and specify alternate methods for keeping a factory in a clean state. Disposal of waste and effluents. Section 12(1) lays down that effective arrangement shall be made in every factory for the treatment of wastes and effluents due to the manufacturing process carried on therein, so as to render them innocuous, and for their disposal. Section 12(2) provides that the state government may make rules prescribing the arrangements to be made under subsection 1, or requiring that the arrangements made in accordance with subsection 1 shall be approved by such authority as may be prescribed. Section 13. Ventilation and temperature. According to Section 13(1), effective and suitable provision shall be made in every factory for securing and maintaining in every workroom a. Adequate ventilation by the circulation of fresh air, and b. Such a temperature as will secure to workers therein reasonable conditions of comfort and prevent injury to health. It is further provided that walls and roofs shall be of such material and so designed that such temperature shall not be exceeded but kept as low as practicable. Where the nature of the work carried on in the factory involves, or is likely to involve, the production of excessively high temperatures, such adequate measures as are practicable shall be taken to protect the workers therefrom, by separating the process which produces such temperatures from the workroom, by insulating the hot posts or by other effective means. Section 13(2) empowers the state government to prescribe a standard of adequate ventilation and reasonable temperature for any factory or class or description of factories or part thereof. According to the Section 13(3), If it appears to the Chief Inspector that excessively high temperatures in any factory can be reduced by the adoption of suitable measures, he may, without prejudice to the rules made under subsection 2, serve on the occupier an order in writing specifying the measures which in his opinion should be adopted, and requiring them to be carried out before a specified date.